I want to thank everyone out there for joining us today. My name is Joel Griffith, and I'm a research fellow here at the Heritage Foundation. It's my pleasure to be hosting today's event on how legislators can curtail a governor's shutdown powers. Before we dive into this discussion, I'd like to remind all of you that we want you to be part of the conversation today. So please, go ahead and submit your questions throughout the event in the questions box. Be sure to tell us your name, your affiliation, and where you're tuning in from. And we'll be getting to as many of those questions as possible later on in this program. We'll also be sharing a copy of today's conversation. We'll have that recording available in about 48 hours following the event. So we have a great panel lined up for you this morning. I'm delighted to invite our speakers to join me on screen now as I tell you a bit about them. So from left to right, we have Carrie Ann Donnell. She is president and founder of the American Jurist Link, and that helps lawyers advance freedom and the rule of law in courtrooms across the country. Carrie Ann considers herself to be a recovering lawyer. She spent the first part of her career litigating for liberty in Arizona under Clint Bolick, who is actually now on the Arizona Supreme Court. So American Jurist Link helps litigators strategize and leverage their resources so they can score more wins for freedom. Next, and I'm looking at the bottom of the screen on this left to right, so apologies for the confusion, but we have Robert Alt. Robert Alt is the Chief Executive Officer of the Buckeye Institute, where he also serves on their Board of Trustees. I'm especially happy to have Robert Alt here because he's in my home state of Ohio. Under his leadership, the Buckeye Institute has seen exponential growth since he took the organization's helm back in 2012. He is also the founder of the Buckeye Institute's Economic Research Center and their legal center. Here we also have John Malcolm. He's a colleague of mine at the Heritage Foundation. He's a vice president here of the Institute for Constitutional Government and the director of the Me Center for Legal and Judicial Studies. And last but not least is my friend and former colleague, Jonathan Hanschild. He's the director of the Communications and Technology Task Force at the American Legislative Exchange Council. I know we have a lot of ALEC members on the call, and he has a keen interest as an attorney in privacy rights. So with that, let's dive into today's topic. Many governors over the past 4 months have relied on emergency powers to issue orders requiring self-quarantining, restricting business activity, restricting gatherings, and limiting mobility. Now that we've begun to see some of these shutdown ease in most of the country, commerce and civic organizations are returning to life, and that's welcome news. And of course, we've seen some very nice jobs growth numbers over the last few months, but we still have more than 15 million people that are unemployed. We have a lot of businesses that remain shut. We see many of them that might not come back to life. And now we see a number of mayors and governors actually threatening or following through on threats to shut down a business or restrict business activities once again. So now is really an opportune time for us to really review the mechanics of these emergency orders, to review their constitutionality, and to push back to mitigate the risk of needless economic damage in the future. So let's start this discussion by examining, has this happened before? What is the historical precedent of emergency powers being issued by governors' offices? And I think let me start with John Malcolm and Jonathan Hanschild on this one.
Well, look, all authority, whether it's the president, Congress, or state legislatures and governors, ultimately comes from the Constitution. So the president acts pursuant to express or implied powers under Article 2 of the Constitution, and the Congress can delegate authority to him through its legislative capacities under Article 1. And they have certain abilities to control what happens in the states through things like the Interstate Commerce Clause and whatnot. But the 10th Amendment to the Constitution basically gives states police power in order to help regulate the health, safety, and welfare of the inhabitants of those states. So Robert Jackson, I mean, in terms of a pandemic, Robert Jackson once wrote in a 1949 case, Terminello versus Chicago, that the Constitution isn't a suicide pact. And there have been pandemics before. So for instance, there's a very well-known Supreme Court case, a 1905 case, Jacobson versus Massachusetts, in which the Supreme Court upheld a mandatory vaccination law undergirded by criminal penalties in order to stop a smallpox pandemic from spreading. And even though obviously people objected to invasions of their bodily integrity, and even though it involved some potential risk by being injected with a small amount of smallpox, that the vaccine could itself give you the disease. But in order to prevent the spread of a pandemic, the court said that the states can do that. And that's sort of what the governors and state legislatures are trying to do now. They're, obviously, if they're going to entrench on a fundamental constitutional right, they have to show a compelling government interest in doing that, and that they can't achieve that compelling government interest in any less obtrusive way. But basically, it's the 10th Amendment, and the fact that they are separate sovereigns gives them that authority.
Well, with that in mind, the parameters that you've laid out, the requirements that there has to be a compelling interest and that it has to be, I guess, nearly tailored or as least restrictive as possible. What have we seen with some of these orders? I'm thinking of particularly the situation in Michigan where the governor for a time was restricting the people within the state from going from their main residence to vacation homes. Have we seen governors breach or potentially breach some of these constitutional parameters on just how far they can restrict constitutionally protected freedoms?
Not sure who that question's for, but yes. First of all, they only have to show a compelling interest if it's entrenching on a fundamental right. You don't have, for instance, a fundamental right to eat in a restaurant or go to a movie theater. Arguably, you have a fundamental right that would to travel. And yeah, look, I think in terms of closing some businesses as non-essential, like gun stores, so that people can't exercise their Second Amendment rights, or restricting churches in ways that, say, department stores are not being restricted, I think intrudes on a fundamental right. Although the Supreme Court in late May came out with an opinion that perhaps gave sanction to allowing greater restrictions on churches.
John, Malcolm, I know that you have written recently on some of the issues of separation of powers as it relates to state legislatures creating the law and the governor's office enforcing the law. So can you dive into that a bit? And other panels, please feel free to jump in as well on this.
Yeah, so as I said before, executives derive their authority either from a delegation from the legislature, unless they have an express or implied power in their own constitution. For the president, it would be the U.S. Constitution. For governors, it would be the state constitutions. And so where you have seen pushback from the courts, actually, they haven't pushed back a lot, but when they have pushed back, it has been when governors have tried to do something that goes beyond the parameters of what the legislature in those states have given them to do. So in Texas, for instance, and in Wisconsin, the governors, in the case of Wisconsin, tried to extend the time to fill out ballots and mail-in ballots for an election. In Texas, they decided to expand the parameters under which one could get mail-in ballots. And the governors tried to do this, and the court said, no, that's not a prerogative that you have under our state constitution, and state law doesn't permit you to do that. If the legislatures want to go back and amend the law to give you that authority, they can do that, but you can't unilaterally take that authority.
I think I kind of connected to that. We've seen so many of these words that we've never really considered before on a day-to-day basis. This idea of allowing essential businesses to operate, but not allowing non-essential businesses to operate, or essential activities versus non-essential. And I think we've seen that too come into play. Well, if you look back over the Easter holiday weekend, we saw that coming into play, but then also even with some of the protests that we've seen across the country. Can you, I know both you and also Carrie Ann have written and spoken a bit about this. Can you talk about some of these distinctions and the arbitrary nature of that, and some of the concerns that you might have with governors trying to determine what's essential and what's non-essential.
Ariane, you want to go first?
Sure, this is one that always gets me excited every time. We saw that non-essential, essential services distinction at the beginning of the quarantine. Now it's, super easy lingo for us in our day-to-day lives. But we're seeing it come up again and become even more nuanced in reopening. So a lot of states are opening in phases. So now you have even more details, not just essential and non-essential, two different categories, but you've got people pigeonholed into all these different phases. So like in Connecticut, that's my favorite one. You've got hair salons that are allowed to open before nail salons. And what's odd to me about this is, you can and very commonly do see the same cosmetologist, the same customer, and the same salon doing hair and nails. Same place, same people. But the governor says if you're trimming hair, it's okay. If you're painting nails, all of a sudden it's not safe and you can't do it. And this is even when you can abide by the same social distancing measures, you can abide by the same mask restrictions or whatever the circumstances may be. The big problem with this is grounded in the Equal Protection Clause. You've got those at the federal level, the US Constitution, and you've also got that at the state level in the state constitutions. And that says you've got to treat similar things the same. So in the COVID context, hair and nail really is the same thing. You can do both in the same place with the same people, same restrictions. So the governor should be treating them the same under the Equal Protection Clause. And there has been a lawsuit that we're waiting to see the outcome.
Yeah, I guess I would add, look, some of these things seem bizarre and probably have a lot to do with the politics of the individual states. So you've got, landscape architects and medical marijuana dispensaries are essential businesses in some places, but as I said, gun stores are not, attending church services or not. I actually, look, I was the first COVID-19 patient in Washington, D.C. was the pastor of my church, so I have some sympathy for this, but nonetheless, people have a right to congregate. They have a First Amendment right to freely exercise, and that includes, in congregation together. And I see no reason why you would take something that has fundamental rights implicated and apply more stringent conditions to church attendance than you would to, going to a department store. So some of these distinctions strike me as being arbitrary, and lawsuits have been filed, but trying to get rulings on them when the courthouse is closed in anything like a timely fashion has been difficult. And of course, the Supreme Court, as I mentioned, weighed in on a church case, a Pentecostal church out in California, and it was very obvious that the Chief Justice basically said, "Hey, I'm a judge, I'm not a doctor," and was very, very reluctant to weigh in and second guess these emergency orders.
John, I'll chime in with the church services and especially in these distinctions we're seeing, because if you remember, think back to around Easter, that's when we started to see bans on drive-in church services, which is another totally absurd ban. You mentioned the fundamental rights, that comes with a really high standard for regulation. The government has to have a compelling interest, and they have to use the least restrictive means possible to regulate the activity. So can they ban, face-to-face gatherings in churches and elsewhere? The answer so far is probably yes. The pandemic is a compelling government interest. The problem where you have bans on drive-in church services is it's not the least restrictive means. There was a case in Kansas where cars were parked and the cars themselves were socially distanced. The cars were 6 feet apart from each other, and everybody had their windows rolled up, and the pastor was preaching from the parking lot. And in that case, the law enforcement showed up and threatened to fine everybody if they didn't go home. So you've got to use the least restrictive means. You can't just lump in all different kinds of religious activities and come out with a ban. You've got the compelling interest, but you have to have it really narrowly tailored.
Let me make one other point actually about that, because another thing, of course, has happened since then, which is the killing of George Floyd and all of the protests that we're seeing in the streets. Well, the police are not exactly enforcing the social distance edicts that have come down in those states. And you made the very good point that when it comes to enforcing laws, you're supposed to do so even-handedly. So another factor that comes in is like the church will go, look, if you had been applying the social distancing regulations across the board, you might have a decent argument. But what about that group over there in the public square trying to tear down that statue? I don't see anybody enforcing the social distance regulations there, and that may come into play in some of these cases.
Yeah, and to your point, Carrie, you talked about the importance under the Equal Protection Clause of treating all equally. I remember being home a few weeks ago, and I walked into the Walmart, and you see the sign. You can have occupancy. I think the Super Walmart was 1,200 people based on people per square foot, and you're usually there for about an hour. People in that in my hometown, that's where they do all their shopping. And my dad goes to a fairly large church. And for a while, they could not gather, and it wasn't as if they were even this facility that he gathers in holds about 1,000 people, so they could have done social distancing requirements, had about 200 people in there, and had roughly the same amount of people per square meter as you had at Walmart, and it simply wasn't allowed. And yet, the one activity was actually a constitutionally protected freedom versus shopping, which does not necessarily boil down to a fundamental human right. So I'd like to maybe segue over to Ohio, because number one, we have Robert Alt kind enough to be here with us, but also because I've spent so much time in Ohio over the past few months. My dad has a small business, has several hundred small business owners as clients, and I asked him the other day, actually this about a month ago, what's it looking like with your clientele? And he told me, based on the number of closed checking accounts, he estimated that 18% of his clients actually had already, it looks like, gone under permanently. So that was a jarring moment for me personally, to know that so many of those small business owners in that area in Southwest Ohio might not make it. So in Ohio, the governor put much of the state under a lengthy and stifling economic shutdown. Can you tell us some of what you saw, some of the interplay between the governor's office, the state legislatures, and the health commissioner there, Robert?
Sure. So, I mean, just laying the foundation, how this all works. The legislators in years gone past had passed the emergency statutes in question, and those laws gave the governor the authority to declare an emergency in the case of COVID. Once the emergency is declared, the legislature gave to the director of the Ohio Department of Health and I'm quoting from the statute here, ultimate authority, end quote, in matters of isolation and quarantine. To say that this is extraordinarily broad language would be a bit of an understatement. Under this theory, I suppose that God himself is apparently subject to the determinations of the Ohio Department of Health. But it's under this authority that they issued the shutdown orders. Now, again, I think sort of operationally, how does that work? The director of the Ohio Department of Health is appointed by and subject to removal by the governor. So I think ultimately the governor is responsible for the policy that comes out of the Department of Health. In terms of how the authority is vested, it's vested in that particular department. And how did this operate? I think Ohio was pretty aggressive in terms of closing things early on. We have a huge sporting event here, the Arnold Schwarzenegger sort of got his big break in Columbus, and so he has for years sponsored, a weightlifting and bodybuilding competition, which brings in competitors from around the world to Columbus every year. It attracts, I think, over 100,000 participant and spectators. And the governor went ahead and closed down the Arnold to spectators when there wasn't even a single case of COVID that had been identified in Ohio. So I think that's an example of sort of how aggressive and early the state engaged in various shutdown maneuvers.
So, despite the fact that the pain was so extensive, was so broad, and despite the fact it occurred so early on, uh, the legislature, despite all of the rumblings, from what I understand, was ultimately not able to get the supermajority needed to override a governor's veto on ending the more draconian aspects of the shutdown. Um, what do you think
Hey,
the hurdles?
Jonathan
What do you
here
think?
from Alex. Jonathan here from Alex. Sorry for the delay, but having some internet issues at work. So glad to finally be able to join and listen in.
Thank you, and we welcome your contribution as well, Jonathan. Sorry to hear you had those difficulties. So in the Ohio situation, with what were some of the main impediments in the legislature not being able to override that veto? I presume that many of these legislators are hearing from their constituents, yet at the end of the day did not cast that vote.
Yeah, no, I mean, I think part of it, you just need to look at the facts on the ground in Ohio. So the governor and the Ohio Department of Health, while the shutdown was devastating to businesses and employees and was certainly extraordinarily broad in its scope, it wasn't marked by the insanity that you saw in Michigan and some other states. The governor and the Ohio Department of Health did not close church services. They recommended it, but churches were still allowed to operate. They didn't close gun stores. They didn't prevent people from going to their vacation homes or make irrational distinctions between hair and nail salons. You didn't have DeWine claiming that protesters of the shutdown were killing people, then ignoring, lauding, or participating in other protests that he preferred, like some governors. As I said, Ohio closed early, but the governor actually took steps to reopen fairly early, as the country went as well. And I think, perhaps the point that sort of crystallizes this is during the shutdown, there was a popular sort of meme of wine with DeWine, where people, would pour a glass of wine and tune in for his daily briefings. You can still buy wine with DeWine glasses online if you're looking for one. And so, I mean, just to put none too fine a point on it, his popularity was through the roof. During the shutdown, he enjoyed an 85% approval rating, which at the time was the highest of any governor in the country. So I think, quite frankly, why is it that the legislature couldn't muster a supermajority? Because the governor enjoyed so much popular support, both personally and for his policies. Again, there were certainly businesses and employees who were hurt by him. There were protests and individuals who were seeking to reopen, but I think the broad swath, actually he appeared reasonable, and so they were more Ohioans were willing to give him the benefit of the doubt. I think, as time went on, people became tired of the shutdowns, but it was about that time that he began taking the efforts to reopen. And I think that this is the general theme as we're talking about what legislatures can do. Ultimately, of course, politics is the art of the possible, and politics guides the process here, particularly with regard to the legislative response. In those, I think you've seen a lot more angry response in states where the governors have taken these kinds of irrational steps of closing church and constitutionally violative steps of closing churches, closing gun stores, discriminating more blatantly. I mean, I still, don't get me wrong, I think there were some serious mistakes that were made with regard to, they certainly did keep early on to the essential non-essential distinction, which we had encouraged the administration to jettison, and they ultimately did. But I think that did some substantial damage to businesses that could have operated safely during the shutdown, but were not permitted to do so.
Yeah, thanks for that color on that, Robert. What do you think were some of the most, I guess, some of the most beneficial actions that state legislators took, separate and apart from the attempts to actually end the shutdown legislatively? What do you think were some of the best strategies that worked with those legislators in getting to the governor's office?
Sure. I think you've got a number of those things that are still in process, but I think are promising. So, as I mentioned, despite the fact that that Governor DeWine didn't close churches, other states obviously did. And I think there was a genuine concern among the legislature that a future Ohio governor or a future director of the Ohio Department of Health could take more drastic and more constitutional dubious measures. And so the Senate, for instance, passed an amendment to a bill making clear that the ODH, the Ohio Department of Health, does not have the authority to close churches in a pandemic. So that, I think that that's been sent over to the House. I think that that's got a reasonable shot. The House and Senate both passed provisions that would remove criminal penalties and reduce fines for violation of health orders, and that's been sent to the governor's desk. And the House passed a provision that would assert oversight of extended quarantines and shutdowns through a joint committee, and the Senate has a version of that legislation that they're considering, essentially making sure that the legislature is involved in this process, which again, I think we'll talk a little bit more about what states can do here in a bit, but I think that, making sure that as we're looking at these sorts of extended shutdowns, that there are greater political checks are among the most important things that can be done by a legislature.
Excellent. Yeah, I think now is a good time actually to go ahead and segue into the ways in which legislators can revise the existing statutes in a way that can generate bipartisan support and possibly even the support of the governor's office. I think Jonathan Hanschild, I know you are on the line. I'd like to get your input on this as well, because I know you've written quite a bit about this. What should state legislators be doing now to mitigate future economic calamity from expansive orders? Let's get into that. And I really would like the input of all four of you on this one, please.
Yeah, again, thanks for the question. That's a good question, and I've devoted a fair amount of thought to that. And again, sorry for all the technical difficulties earlier. The internet at work just decided to give up and was working through that. But when we look at some of the proposed some of the solutions, we also have to look at what some of the large-scale problems are. So when we're talking Ohio, Michigan, Pennsylvania, and other states, some of the problems that exist because the legislation is substantially similar. A lot of states back in the mid to late 70s revised their emergency management acts based off of a model that was kind of drafted by the Council of State Governments. The Council of State Governments, when you do some of the research, you find that the purpose was to give governors more authority, was to streamline the process so that it was a one-size-fits-all for every emergency. So now looking at the different types of emergencies we're seeing now, we're seeing some potential solutions kind of suggest themselves. One of those solutions, perhaps key among them, is really twofold. The first is to recognize that not all emergencies or disasters are created equal. What do I mean by that? Well, we're seeing social unrest with some rioters on the edge of protests creating havoc. Well, you don't want to handle a riot the same way you handle a pandemic. Yet the legislation in states that allows governors and local governments to respond is the same legislation. So key point number one, start narrowly tailoring the laws, the emergency management laws, for specific types of emergencies. You may want to give governors or local law enforcement a substantial amount of authority to put down riots for a very limited amount of time. But if you have a pandemic or you have something that's longer term, you may not want to provide them the same amount of authorities. And the same is true, you may not want to provide the same authorities if there's a flood or if there's a wildfire or tornado. The second part is when you have a longer term emergency, like a pandemic, you have to, as many of the speakers have already talked about, you have to narrowly define the authorities of the governor and make it very clear to society and to the courts that certain things are to be protected, such as individual and constitutional liberties, along with the fact that states should, in certain situations, be required to follow laws that exist for specific purposes. So one of the things that we're seeing in the pandemic is that most states have what I'll call communicable disease laws, and those communicable disease laws are created for such a time as this. to deal with highly contagious and communicable diseases. And guess what standards states are not following? Communicable disease laws. So those solutions should also make it clear that state laws designed for emergencies such as this still apply, and that there is no excuse for the government not to follow it.
Yeah, thank you for that, Jonathan. So it sounds like we've got a big problem here of really some of the statutory language being quite vague, and there not being a clear enough difference drawn between emergency powers, communicable disease laws, and there's many governors that have taken some expansive liberties with communicable disease laws by interpreting that language more broadly than the powers given them under the overarching emergency powers. Do I have that right?
It's actually kind of backwards. They're taking very broad and vague language from the Emergency Management Acts and ignoring the communicable disease laws. So, for example, a lot of the model Emergency Management Acts have a provision in there that allows governors to control, quote, ingress and egress, end quote, to disaster areas, and, quote, the movement within the disaster area, end quote. And when you're talking about shutting down non-essential businesses, when you're talking stay-at-home orders, that's the specific provision governors cite for the authority to do it. They completely ignore the communicable disease laws, which often have language to the effect, or not just to the effect, but that state that only, quote, an individual, end quote, that's confirmed to have the disease may be quarantined or isolated, or, quote, an individual or individuals that are reasonably suspected of having come in contact with an individual confirmed to have the disease, end quote. So just based off the statutory language, you have an individual. You do not have groups of people. You do not have society. And the second part is there has to be a reasonable belief that they have the disease or been exposed. So you can't just quarantine or isolate healthy people. If governors were following their state quarantine laws, their state communicable disease laws, they wouldn't be allowed to issue these stay-at-home orders. So that's when I go back and say that state emergency management acts should be very clear about the authorities of the governor and very clear about what laws they can ignore or suspend, and very specifically state, for example, in a pandemic, that the state must follow the communicable disease law.
Yeah, thanks for that clarification, Jonathan. I know that one of the biggest problems that we've seen across the country with emergency orders is that governors will issue it. There's a set expiration date of, say, 30 days. I think we saw this in Pennsylvania. And because of the way the empowering legislation is drafted, the governor can then go ahead and just reissue another emergency orders and just really pyramid these orders one after another, even though they're technically only supposed to be temporary. I know that John, Malcolm, you have talked about the need to have affirmative legislative approval of these orders. Can you talk about what that means, what that would look like?
Well, I want to respond a little bit to what Jonathan was just saying, which is it's in order to do with the communicable disease law that you just talked about, you'd have to have extensive and probably mandatory contact tracing, which has its own set of issues. And it's a little bit difficult when you're dealing with a pandemic where somebody could be exposed and actually a carrier and be completely asymptomatic, but everybody they come into contact with is potentially impacted in terms of lethality. So a balance has to be drawn. But I absolutely agree that if you open things up and you give these incredibly broad delegations of authority in terms of either how to act or under certain circumstances, or the ability to keep renewing emergency orders without in any way, shape, or form having to come back to the legislature to have it ratified, again, you're going to have problems, and that's at the federal level too. I mean, there's the Federal Emergencies Act, where there are emergencies that are supposed to be under the statute temporary in nature, but they are renewable by the president, and there are literally emergencies that have been extant now for decades that people don't even really know about since the time that the Federal Emergencies Act was enacted. Legislatures need to flex their muscles more. If they are concerned about this, they need to be robust in terms of reining things in. I realize that this is a delicate balance because sometimes legislatures can be divided, they can be sclerotic, and executives are there to be able to act quickly and, as Hamilton said in the Federalist Papers, with verve and dispatch. But there needs to be a balance, and people need to be attuned to the authorities that they grant to the executive, and whether it applies in this situation or that situation. And at the end of the day, unless something is in a state constitution that gives a governor authority to act regardless of what the legislature has to say, the legislature is the one that controls all of the cards.
I just wanted to add something to what John said there, which is when you talk about sort of the long-term effects, I think the first rule for the legislators has to be first do no harm. And you see this with regard to these emergency measures that become permanent. And I think the classic example on this is rent control in New York. And rent control in New York City in particular. Rent control, there was, I believe it was actually federal legislation which permitted rent control in World War II. The state of New York implemented a rent control measure following that, extending the provision. And there were a series of extensions after World War II, all citing back to World War II through the 60s and forward. Well, it came out in 2019. They reauthorized rent control in New York City, hearkening back at least in some measure to the original rent control measures and to the crisis of World War II. I'm guessing that they've addressed the housing shortages from World War II by now in New York City, but that's still ultimately the justification. And so you want to be careful about these temporary stopgap measures that are put into place. I'll give you one example of something that raised grave concern here in Ohio, and that actually caused the Buckeye Institute has filed a lawsuit over it. Ohio has the most bizarre and complicated local income taxation system in the country. There are some states that have a commuter tax for New York City or so forth. In the state of Ohio, there are literally hundreds of different taxing jurisdictions. It is permissible to be taxed both where you have local income tax, both where you live and where you work. And so based upon this, we had two conflicting measures that went into effect. The governor, through the Ohio Department of Health, issues an order which says you shall not enter your workplace. If you're able to, you should work from home. That's order number one. Order number two, which actually was issued by the legislature, says for the purposes of local income taxation, you will be deemed to have worked in your office during the shutdown. And that applies even if the local income tax that you would pay in your office is higher than what you would have paid from working at home. Well, as luck would have it, the Constitution does not allow legislators to tax based upon the let's pretend theory of where work was performed. And so Buckeye has filed a lawsuit challenging that. But part of the reason I was explaining to a reporter just a little bit ago, one of the big reasons we did that, it's important for the initial principle, but it really goes back to this rent control in New York theory. If the government is allowed to tax based upon let's pretend, if we remove any sort of constitutional limitations on the nexus of sort of any sort of fiscal actions taken by the employee, then Katie, bar the door in terms of what you'd be able to permit in the future.
Right, that's shocking, Robert, on both accounts, New York City and that case. I want to take a pause here just because we're at about 20 till and make sure that people have an opportunity to submit questions. We do have a few in the queue, and actually a few actually appear to tie into this last component that would be great to dive into. But as a reminder, we have the instructions on how to submit the questions. If you go to the right-hand side of the screen, you can submit those questions in the question box, and we'll try to get to those. I know we've touched briefly on Plan B, right? If legislatures don't move forward and revise these statutes can we work through the courts in some of these instances? I know you've mentioned a few of these cases, Robert, but on constitutional grounds, we've seen legislators in Wisconsin, for instance, actually sue in the state Supreme Court to block a shutdown order that they said exceeded constitutional bounds, and they actually won. I was wondering if maybe Carrie Ann could talk about the details of that Wisconsin case, and what are some of the important takeaways that state legislators elsewhere should learn from what happened in Wisconsin.
Yeah, Joel, I'd love to kick that one over to Jonathan if he's still on the line. I know he's had some thoughts on this and would love to hear from him first.
Yeah, I'm still here. The Wisconsin Supreme Court case is a little unique. It's different from a lot of other state decisions that we're seeing. And that's because the state Supreme Court really didn't reach the constitutional question. Wisconsin has something of a unique procedure for emergency orders. The governor can still promulgate emergency rules. The Secretary of Health can still promulgate rules, but they have something of a state-level Administrative Procedures Act that requires notice and comment on an expedited basis for certain types of rules to take effect. The legislature basically alleged, and the state Supreme Court accepted, that the stay-at-home order and the order shutting down non-essential businesses, and it was one order, was in fact a rule and should have been gone through the State Emergency Procedures Act. The state Supreme Court agreed, and so struck down the order on the basis that the governor and the Secretary of Health failed to follow the proper procedure. What does this mean for states is a good question. Well, they may want to take a close look at the model from Wisconsin, because that provides the governor some flexibility, and it also provides the legislature a opportunity to kind of check the authority before it happens. Supreme Court also reached a couple other statements, and again in Wisconsin, that could be used in other states, citing the fact that the purpose of the Procedures Act, the purpose of promulgating emergency rules, is because there may not be time for a whole of government response, for the legislature and the governor to work together. Legislature may be out of session. It may be such an exigent emergency that there's no time for legislation. And so that's when the governor's authority in Wisconsin is at its zenith, at its maximum.
And Joel, I think, Jonathan, let me jump in and comment on this.
Yeah, go ahead.
Just broadly, these procedural challenges in the courts tend to do much better than some of the constitutional challenges. Courts like really well-defined, simple, easy to follow rules, right? If you ask a judge at a trial court or even the Court of Appeals, sometimes at the state Supreme Court level, they don't like the pressure of having to weigh a constitutional right against a public health concern. They hate those decisions. It makes them very uncomfortable. And, they would much rather just leave the status quo and defer to whatever somebody else has ruled. They're not making these life and death decisions or striking things down. But when you ask a judge, did the governor break the law because he didn't follow notice and comment rulemaking procedures? That's really easy. That's very easy and simple. A judge is much more comfortable saying, I'm not saying anything about constitutional rights or public health or how bad this virus is or how overblown this virus is. I'm not making those judgment decisions. All I'm saying is the law says you have to give notice. The governor didn't give notice. Therefore, the thing's invalid. And so we definitely see procedural limits as a really strong protection for, that can be enforced. It has a lot of teeth, and that's something that our judges are much more likely to uphold in some of these really tough cases.
Jonathan, ALEC has quite a bit of model policy on many different issues. Is this an area that there's already some models that you could provide, or is this something that you're working on for the future?
So we're working on it right now. We have our annual meeting next week, and thanks to the virus, it will also be a virtual format. There are a number of policies that have been introduced by state legislators on this topic. We have a statement of principles to inform Emergency Management Act reform. We have a draft, and these are all draft Emergency Power Reform Act. Other task forces are taking a look at this very specifically, a resolution on overcriminalization and pandemics. So this is a topic that is of great interest to state legislators. State legislators, encouragingly, are trying to come up with solutions, and they're trying to come up with the solutions that are balanced, recognizing that the governor does in fact have a role, and that the governor can do certain things better than the state legislature can, and should have certain authorities, but that also that there should be certain limits. And I think what you're going to see based on some of these conversations, some states will go the legislative route and maybe work with governors or put pressure on governors. Other states will go the state constitutional amendment route. And what we will see in the coming year and years is a host of solutions coming from state legislatures, all of which are at least a step forward, many of which are really good, thought out, measured approaches. So the short answer to your question is yes, ALEC is considering it. People can right now go to our website and look under specific task forces. So the website is alec, ALEC.org. And the draft model policy is published on the website under the Homeland Security Task Force, Civil Justice Task Force, and Criminal Justice Task Force. And I believe the Federalism and International Relations Task Force has also published some.
Okay, great. Good to hear. We have a few questions, and these actually revolve on the legal constitutional law front. One is in regards to the takings clause of the Constitution. And for some of the non-lawyers that might be on the call, this simply says that if government takes private property, it has to be done with just compensation. And there are a whole lot of other guidelines in there that it has to be for public use, for instance. But with these regulations that have been imposed by governors, there's no doubt that those regulations have caused some businesses to go bankrupt. It's also caused some businesses to lose revenue. It's caused business valuations in general for many sectors to go down. Does that count as an actual takings, a takings to the extent that a business owner could actually sue and win damages from the state for the imposition of those regulations? I'd like to open this up to actually to all four of you who are attorneys on this call.
Well, all right, let me jump in on that one. And unfortunately, the answer is probably no. And here is, which is why people who have been filing these suits have been losing them. And what I'm about to say, I'm not saying I agree with, but this is what the law is. So the Fifth Amendment takings clause requires just compensation if property is taken for a public benefit. So, I want to build a government center of some kind, and I condemn your house, or put in a roadway, I condemn your house, I have to pay you just compensation. There is a whole other body of law referred to as a public necessity, which is not considered to be a public benefit. So there's, you can have this on the private sector too. So for instance, if I'm walking along and a big storm comes along and I seek shelter on your property, that was a private necessity brought on by circumstances, and you can sue me for damage if I damage your property, but you can't go after me for trespass. In the same way, if a state official takes property, if you will, out of public necessity, they fire tear gas into your home and destroy your home in order to flush out criminals that are in your home. They destroy your home in order to set up a fire break or a flood break to prevent a fire or flood from spreading into a town, that is not considered a taking. And similarly, there are actually cases on this where there are animals that have communicable diseases, and they destroy a farmhouse that had the animals in it in order to, get rid of the disease. That is not considered a taking. And so all of these cases that have been brought so far, courts have been looking at these and saying, well, yeah, your property was taken. Maybe they ought to pay you some money because it's the right thing to do. But it was not for a public benefit. It was done out of public necessity to prevent the spread of a pandemic.
You have any
John,
thoughts to add on
I'll
that,
try
Carrie?
to. Joel, the other problem with these filing these types of takings cases is these aren't your basic level takings, right? You think the government comes in and takes your property, meaning, John, like you said, they set it on fire, or they literally take it because they're building a road, or they take title to it. The government isn't doing that, right? The government isn't coming in and taking somebody's restaurant. They are regulating somebody's use. They're saying, you can still have your restaurant. You just can't open it. You just can't use it. So you're basically, they're regulating you out of the value of your property. And that's a type of taking called regulatory takings. And it's an incredibly high standard under the law. I think there are cases saying the government has to regulate or deprive you of 99.4% of the value of your property before the government's going to, before the court's going to order the government to actually compensate you for it. And that we don't have that here. I mean, if a restaurant can have carry-out services and not dine-in services, we can't say that the government has taken 99.4% of the value of their property. If a gym can open at 25% capacity, you're not reaching that really, really high threshold of saying the regulatory taking is essentially a taking under the Constitution. And that's another problem. Joel, your question was, can you win these cases? And John, your short answer was no. My answer would be I wish, and maybe someday. So we're trying to push the law a little bit more in that fairness area, but we're pretty far from it right now.
I think that this, points out sort of the larger issue and something that's useful in terms of framing things for the legislatures, which is to say, again, if you look at the broad swath of the cases that have been brought, you begin with, sort of a pretty steep hill when you're challenging government discretion. If the governor or the Department of Health or whoever is issuing the regulations is acting based upon delegated discretion that's given to them, the bottom line is, looking at, for instance, the case, that went up to the Supreme Court with regard to the churches, judges are going to be very nervous about inserting themselves in the place of the legislature or the governor or whoever it may be in terms of making the determination on the shutdown. They're far more likely to go ahead and enter a judgment against an order if it clearly violates a bright line standard. You went beyond 30 days. You regulated a class of activities beyond those which you were authorized to do. Those are ones where you're going to more likely win in those cases. So, as the legislators are looking at these questions, putting in those kinds of guardrails, putting in the temporal guardrails, putting in the legislative checks where, okay, if it's going to go on in perpetuity, you need to have some sort of a political democratic check on the exercise of this authority. And again, that doesn't say that in proper circumstances, you wouldn't have continuing quarantine orders. Indeed, I think Ohio is the example of why that would work. You actually had popular support for the governor. And if you have popular support, then they continue. When the popular support wanes, then this provides a check to be able to actually make sure that that proper constrictions are followed.
Yeah, thanks for all that, Kel. And I think that really highlights the importance of not just completely relying on the courts to remedy some of these economic problems. It really shows the importance of legislatures abiding by their responsibility to actually create the law and do so in a way that is so clear that a governor has to abide by those constraints, and that a court, if they look at it, can more easily make that determination instead of wading into political controversies. Legislators have just a huge responsibility on that.
Unless it's a contract dispute, if you're waiting for courts to step in to protect your property rights, you are probably barking up a wrong tree. And going a legislative route is probably a better way to go.
We have another constitutional law question. We just have time for probably maybe two more here. So we've talked a bit about the hurdles that a governor or legislator has to meet anytime that they're restricting a fundamental constitutional right, such as the freedom of religion or the freedom of speech. Yes, there are instances in which that right can be restricted, but it has to be a compelling government interest. It has to be nearly tailored in the least restrictive means possible. But what about some of these other rights that we enjoy as Americans? The right to run a business, to engage in commerce, to go shopping. When it comes to those liberties that we enjoy, do the protections that we enjoy are they elevated to the same level? Can we talk about that a bit? The freedom of commerce, the freedom to run your business, the freedom to go shopping.
Well, Carrie Ann before I think was saying that there is no constitutional right to shop, and I think that's right. There's no constitutional right to shop. I mean, you've got sort of freedom of movement, but states, Congress has the authority to regulate interstate commerce, and states have the authority to regulate intrastate commerce. And if they're doing so in order to protect public health, their power is probably at its zenith. And indeed, the courts have basically said that Congress can even regulate intrastate commerce, except for under the most narrow of circumstances. So yeah, look, there are other rights that are explicitly stated: freedom of assembly, petition your government for redress of grievances. Even those can be curtailed. Whatever constitutional right there is to shop, I think, is very much imperiled if there is a pandemic going on.
I suppose one thing I would add to what John has said is, there are many of us in the freedom interest law movement who have lamented for decades the short shrift that economic liberty gets before the Supreme Court. I mean, there's sort of a hierarchy of rights, and regrettably, economic liberty does not tend to get good protection for some of the reasons that John and Carrie Ann have already discussed. Based upon, for instance, in the regulatory taking context, the degree of taking that has to occur before you can even, sort of essentially state a claim. And so you begin, sort of on an ordinary day when there's not anything going wrong, you're going to have a tough day in court. But when the government gets to play, sort of the card of we're protecting the people from a pandemic, at that point, I hearken back. I was a student of Richard Epstein's at Chicago, a noted libertarian, and he had a statement: in certain contexts, when you're fighting the government, the rule is what Lola wants, Lola gets. And I think, with regard to dealing with, sort of economic liberties during a pandemic, regrettably, that I'm not saying it should be the rule, but in far too many cases, it is the rule.
Thanks for that. And another, I think we have time just for one more question. I know we have so many to get to, but are we at the point with any of these orders where civil disobedience, nonviolent civil disobedience, has been warranted, in your opinion?
Well, I never like to tell anybody to violate a law, but sometimes civil disobedience, if you're prepared to pay the consequences of being civilly disobedient, can be an effective political tool. And you are seeing certain church services, for instance, that are saying, look, I understand that I'm going to be violating this by gathering at a church service with my fellow parishioners, and if you want to haul me off to jail, okay, you can haul me off to jail. I'll pay the consequences of that. So long as you're prepared to pay the consequences of it and it's nonviolent, then you can end up having potentially an effective political message. It is a way of getting your word out there, in the same way that the people who are in the streets now who are peacefully protesting are having their voices heard. And so long as they're not rioting and looting, that presents a whole different kettle of fish.
let me give an example of a case where I think it certainly was justified. There were out in Idaho, there was a prohibition with regard to gatherings that included protests, peaceful protest gatherings, even if precautions were taken. And there was a public policy organization that arranged for a protest rally. I believe it was at the State House. And this was considered an act of civil disobedience. But I think it's one that is broadly protected by the First Amendment to the Constitution. I think once again, it's not permissible for the state to completely quash any kind of reasonable protest, dissent, petitioning of legislators. Particularly where in this particular case, I don't think they permitted any sort of a reasonable accommodation. So I think that would be an example of something where civil disobedience is justified under the Constitution.
Well, thank you. I know that was it's been an interesting hour. I think we could go on for another hour with so many of the great questions that have been submitted. I do want to give you a brief chance to give any final thoughts before we conclude today.
It's just been a pleasure being with you all and my fellow panelists. I think this is a great topic, and let's hope it's a topic that passes quickly along with the pandemic.
Yeah, Joel, thank you for organizing this. It has been a very interesting and informative discussion, and really privileged to participate in it. Like John, I kind of hope this is one that passes quickly, but at the same time, state legislators should look at the lessons learned and realize that the potential for abuse does exist and plan against that potential. And any solution really needs to balance the appropriate responses and the ability of the government as a whole to protect the public health and public safety. And at the same time, this, like I said, this delicate balance of then protecting individual and constitutional rights. It's something that's best done by a combination of the legislature and the executive, and with the occasional input of the judicial branch when certain things may step over other rights. So it's just a great opportunity for state legislators to take a good, hard look at a bunch of laws that haven't really been updated since the 1970s and prepare for any potential future emergency.
Thank you, Jonathan.
And I would just, sort of reiterate a theme. I think there's a genuine opportunity. I too hope that this is short-lived, but I think that there's a responsibility for the legislatures as well as for the citizens in terms of holding the legislatures accountable to make sure that that we don't have temporary provisions that were meant to address the crisis become permanent in ways that are detrimental, like the rent control provisions in New York, or the unconstitutional tax provision here in Ohio. And it also provides a real opportunity to see what worked and what didn't, in terms of how it is that these states conducted the shutdowns, and what checks need to be put into place by the legislature to guide the discretion of the governors in the future.
Yeah, I think the opportunities are so explosive right now. It's easy to get bogged down by the direction that we're heading, but at the same time, we have the opportunity to make fast and far movement, and we're doing that in some areas. And so just as much as we have so much work ahead of us, that same work is also an opportunity. When I was in public interest litigation a number of years ago and on the front lines in the courtrooms, I would always joke with Clint Bullock about how our dream was to put ourselves out of business as constitutional lawyers, and we are pretty far from that right now. I would say our workload has really skyrocketed these last few months with all the constitutional challenges that have popped up, and as quickly as we're navigating those. But the more that we do and the more wins that we have, the closer we will get to changing our career paths, which would be a dream.
All right, well, thank you so much. I want to thank each one of you on the panel for being here today, and to everyone who was listening virtually online. It's a great conversation. I think it's an important one. If you work on the Hill at a think tank, or if you have any questions, you can reach out. You can contact me, joel.griffith@heritage.org. I will connect you with the right people, give you any resources that I can deliver. You'll receive a survey after this event. Please do complete it so that we can continue to make these better with each one. And we'll give you complete update on any events that are upcoming. So thank you so much, and have a great afternoon.